Yes, Mr. Emerson.
I wonder if I may now to turn to the evidence that you've heard concerning those people who were detained at Jablanica and what they say about whether they did or did not see Ramush Haradinaj there at any time and what can be inferred from that. First of all, you heard testimony from witnesses 75 and 76 in connection with the detention of their relative, who they said was detained on several occasions, but was held for a considerable period up until the end of May, and that they visited the compound on numerous occasions and saw various members of the staff there. And they both stated in terms that they never saw Mr. Haradinaj in Jablanica on any of those visits. That's transcript 1845 and P304, the witness 7692 statement at paragraph 13. Witness 75 stated that it was Lahi Brahimaj who was in charge of Jablanica during the period he went there, and accurately that Mr. Haradinaj was not yet commander of the Dukagjin area. The testimony of Shevchet Kabashi that was admitted in these proceedings from the Limaj trial, he said that he had been based in Jablanica as a KLA soldier consistently from April through to September 1998. And his evidence was that there was, during the whole of that time, no one in a more senior position to Lahi Brahimaj in command of Jablanica, and there is no suggestion whatever in that testimony that during the whole of that time he ever saw Mr. Haradinaj anywhere in Jablanica. Now, we know he did go to 2 formal meetings there. We know he did go to intervene on Skenderkuchi's behalf. And we know that he did go on one occasion, according to witness 80 at least, when he was surrounded by other people and there were villagers present in the staff in the main part of the village, not the so-called detention facility. But Kabashi never saw him there. So the suggestion that Mr. Rogers tried to make that Mr. Haradinaj was a regular visitor doesn't appear on its face to be consistent with the testimony of any of those witnesses. But what about witness 3? Witness 3 was, on his evidence, detained at Jablanica for a considerable period of time, escaped, was taken back there. And of course, he came across Ramush Haradinaj for the first time when he got to Gllogjan. And after that, as we've seen, nothing ever happened to him again. In other words, he did not see Mr. Haradinaj at Jablanica. What about witness 6? Witness 6 is significant because, as your honours know, he was detained for 6 weeks from the 13th of June. His testimony, which has been admitted, is that a day after the escape on the 18th or 19th of July, he was freed within the confines of the compound. In other words, he was, to all intents and purposes, by appearance, he was working in the kitchens and free to move around the compound, albeit that he was still detained. So it's not as though he was locked in a room where he wouldn't have been able to see anybody coming or going. He would have seen all comings and goings in and out of the compound. Let me read you his testimony from trial 1. This is page 5391. He's asked about when Skenderkuchi goes to hospital, and he says, I don't know, I didn't see him, but when I took bread to Pal Krasniqi, he, Skenderkuchi, wasn't there anymore. And might that have been, question, and might that have been a day or two after the escape attempt that you've described? And he says 1 day after. And from that point onwards, just so that we have the picture, once again, there was only one person in detention, namely Paul Krasniqi. Is that correct? Answer, yes. Question. You were still not free to leave, but to external appearances, you were wandering around the yard and washing the dishes and so forth. Is that right? Answer. That's right. And then a little further down, and just one final question on timing before I ask you one or two other matters. Do you know how long it was after you got your relative freedom that the man from Zahac arrived? 1 or 2 days after that. I can't be very precise. Thank you. Question. What I want to do now is just to put 1 or 2 passages to you, witness 6, from, first of all, the witness statement that you made in February and March 2004. That was the statement that you made when you were shown some photographic lineups, and you were shown a lineup of photographs that included a photograph of Ramush Haradinaj. I won't bother to pull it up on the screen, but I'm just going to read to you the passage from the witness statement that you have signed and ask you to confirm that it is correct. Having been shown the photograph, which was a lineup including a photograph of Mr. Haradinaj, you said this, and I'm quoting from your statement at paragraph 3, quote, I can identify Ramush Haradinaj. While his face has become familiar to me after the war, from several newspaper articles and television programs, I did not know him from the time of the war and cannot remember seeing him in the KLA prison in Jablanica. Question. I'll ask you, please, to confirm that that is a correct statement of your evidence. Answer, yes. So witness 3, who was there for 6 weeks and moving freely around the compound from, I'm sorry, witness 6, did I say 3? I do apologise. And moving freely around the walled compound from around about the 18th of July. He never saw Ramush Haradinaj there either. And so we are left with Mr. Rogers' speculative theory as the only evidence that the prosecution can point to connecting Ramush Haradinaj to any of these crimes. And the theory goes like this. You can be sure from the testimony of the protected witness that the 3 boys were arrested and taken to Jablanica prior to the attack by the Serb forces on Grabanica, and you can be sure that the occasion when the protected witness saw Ramush Haradinaj surrounded by a group of men inside the staff took place after the attack on Grabanica, probably a week after. Therefore, they must have been in detention all the way through at Jablanica. And even though the protected witness didn't say that he saw them there that day, the prosecution say Mr. Haradinaj must have known that they were there. And therefore, the prosecution say he must be complicit in a joint criminal enterprise. That, as I've understood it, is the way that Mr. Rogers is finally driven to put his case. The short answer is this. Whilst one cannot but admire the forensic ingenuity with which he sought painstakingly to build the elaborate edifice of inference that he's inviting you to draw, its foundations rest on sand. First of all, Your Honours are going to have to read the testimony of the protected witness with care, because as regards the dates, the days and the occasions, he was multiply inconsistent. The suggestion, and it's made in the prosecution brief at para 211, quotes, there can be no uncertainty that the count 1 victims were executed after Haradinaj's visit simply cannot be derived on any rational view from a reading of the testimony of the protected witness as a whole. He said in clear terms, when asked directly about the timing of those two incidents, that the incident with the 20 or 30 villagers took place before the ear-cutting incident had occurred. That's T2414. He then underscored that by making it clear on several occasions that the incident with the villagers took place after the Serb attack on Grabanica, but that the incident with the boys being arrested and detained took place before that. Now, Your Honour's punctured the myth with a simple question in the course of Mr. Rogers' submission. Do we know, on the evidence, when the boys were taken to Jablanica? Answer from Mr. Rogers, no, we do not. That is the end of the matter. Because unless the prosecution could prove that beyond reasonable doubt, the date on which the boys were taken to Jablanica, they couldn't begin to invite you to return a conclusion that they must have been there on the day that Mr. Haradinaj was there with the 20 or 30 villagers. That's the end of it. But even if it weren't the end of it, and even if they were there, and even if it was possible to draw that inference, the protected witness didn't see them there. So why should Mr. Haradinaj have seen them there? Because the protected witness and Mr. Haradinaj were in the same building, the staff, in another part of Jablanica. So how can Mr. Rogers suggest that Mr. Haradinaj must have known that they were there when the protected witness himself, if even on Mr. Rogers' completely speculative theory, didn't know that they were there at that time? The fact of the matter is that, and I'm going to invite Your Honours to, and it'll need to be done with care, to go through each and every time when the witness tried to locate the dates of occasions, and you will see that they are wholly inconsistent the one with the other. So, for example, there is a reference to a village called Buchan in the evidence, and to detentions having taken place. Perhaps this part I ought to do in private session, in fact.
May the Chamber please move into private session.
Your Honours, we're in open session.
Thank you, Mr. Registrar. Mr. Emerson, the Chamber did say it's not going to impose time.
I'm moving to the end.
Sharing this day with two other council, how long are you going to be?
I shall be no longer than another 20 minutes, and then I'll be finished.
20 minutes?
Yes.
Proceed.
I've obviously timed my submissions in the light of the indication that Your Honours gave this morning.
Indeed, but this time must be shared equally with, at least the other two must also have enough time to.
Yes, but Your Honour indicated this morning that, if necessary, you would go into tomorrow.
The first preference is we finish today.
Well, let me move things along quickly, if I can. Then, can I then just deal briefly with the evidence of Zoran Stejovic, because Mr. Rogers introduced him when he opened the case on the basis that the documents that Mr. Stejovic produced were given to the trial chamber, quotes, for what they're worth. And he had to make that concession because over a period of time, Stejovic had acknowledged in one form or another, although it had to be drawn from him like teeth, that the material that he was producing was often anonymous, and that the methods by which it was obtained included bribery, blackmail, and on the evidence, the possibility, the real possibility that couldn't be excluded, of torture. But in their closing brief, this material is quoted liberally, and indeed Mr. Rogers cited the testimony of Mr. Stejovic specifically to you in order to justify the suggestion that there was a close association between Mr. Haradinaj and Mr. Balaj. So we have to deal with it. And can I deal with it just by taking you to a few short passages, please, in the video evidence of Mr. Steervich from trial 1 and then from this trial, because you'll see how his testimony evolved. First of all, tab 23. This is trial 1, when he begins to explain the RDB Secret Service's methodology in obtaining the material that the prosecution have chosen to put in evidence and rely on.
By your leave, I propose to use a term, a live source, which means that it's a human being providing information to us. I think that would avoid any further miscommunication and help us avoid confusion in the future.
200 people you referred to in the KLA before, are they live sources?
Da.
Yes.
How were people in their category rewarded by the state security?
Znači, motivacija tih ljudi.
The motivation of these people in their work with the State Security Service was diverse, just like anywhere else. The basic element was money. The second possible motive was of political nature, where they did not agree or they disapproved of various activities. And the third motive was to compromise somebody. If we had information about somebody that was of compromising nature, then we would resort to blackmailing. I'm using that term because this is what it amounts to everywhere else in the world. And in this category, we are mostly dealing with partially verified information. And these people worked under a pseudonym. They would only be mentioned under a pseudonym in various reports. If you wish, I can explain our methodology and tell you how we made contact with such people.
If it assists the trial chamber?
I leave it in your hands, Mr. Ray.
I anticipate that the defence will ask the question, so I might as well get in first.
I'd certainly like to hear a little bit more about the blackmail, if possible, in chief.
Mr. Steervich had no problem using the word blackmail in trial 1. And he does give a little further evidence of the fact that in a society riven by blood feuds, evidence that one person, A, was having an affair with the wife of another person, B, was a very potent tool. It was really effective blackmail. Can we just look at how he explains that in trial 1?
Just return to
At number 26.
what I was asking you a moment ago, when armed with that information of, quote, immoral behaviour, unquote, how did that, in your professional experience, affect the assessment of the reliability of the information you received from those immoral type people?
Znači, stepen kvaliteta.
The quality of such information in such an atmosphere with predominating patriarchal moral principles, when one finds out that there is a case of adultery among relatives, that there is a situation which could be of compromising nature, not only for the persons involved, but also for the entire family, that could lead to some very typical consequences, such as blood revenge or blood feud, which exists in Kosovo and Metohija. then this was a very good tool for recruiting a person. And the higher the level, the greater the possibility to keep that person under the control.
Just return.
Something had obviously happened between Trial 1 and Trial 2 because Mr. Steervich didn't seem to like the word blackmail in Trial 2. Can we look at tab 25, please?
All I just wanted to ask you, Mr. Steervich, is in that example of A and B, that whole explanation, that whole situation that you explained to us, what do you call that in one word?
To je izbor.
I call it choice. Either you'll work for us, or we will disclose all these immoral things to your friend.
Choice. Thank you so much.
Interpreter's correction. The relationship was between the wife of A and B. Witness's answer, you can call it blackmail.
To mi sada pada na pamet, ja pokušavam.
It only occurred to me now. I'm trying to find another appropriate term in Serbian, but I'm unable to.
Asking you what I could call it. I'm asking you what you call it. In one word.
Ucena.
Blackmail.
Thank you.
So that's bribery and blackmail, but almost more serious than all of that in terms of compromising the integrity of the material that Mr. Rogers relies upon and cited in his closing submissions yesterday is torture. Now, what you're about to see is me cross-examining Mr. Steervich in the first trial, where he had put in evidence certain statements from two witnesses called Bekim and Nasser Kalamashi concerning allegations of crimes by the KLA in the Dukagjin region. And those witnesses had then been interviewed by the office of the prosecutor and had made statements to the prosecutor saying that they were tortured inside Gjakovë police station to make the witness statements that Mr. Steervich had produced and that the prosecution themselves had produced. Sorry, I'm corrected. This was in the retrial? No, it wasn't. It was in the first trial. Well, I think it was in the first trial. We'll see in just a moment. So I'm putting to him, first of all, a lengthy passage. Maybe it was the retrial. I'm putting to him, first of all, a lengthy passage of an allegation of torture, and we see how he responds to it. Because bear in mind, he's put these statements forward as reliable, that's to say the statements obtained by the Serbian intelligence, and the prosecution have put them forward as reliable evidence. Can we have a look at tab 26, please? So we can go back to the witness statement, please, and pick it up at paragraph 15 at the bottom of the page. After the men had been stripped naked and beaten, we had to get on trucks, and on halfway to Gjakovë, the police came, and we were ordered to get on police jeeps and taken to Djakovica SUP. Then we were kept in the basement of the SUP premises for the following 3 days under constant beatings and torture. The police were coming to the basement and taking one by one for questioning. The interviews took place in the office on the 4th or 5th floor. I was arrested and kept there with other 11 co-villagers. When I had been taken for interview in the office...
Are you going to read the whole
Yes,
statement?
I am, because it's obviously being translated for the witness.
Oh, beg your pardon.
When I had been taken for interview in the office, was sitting a man in civilian and asking questions in Serbian language. The only phrases he used in Albanian were as follows: why are lying to us that you had not been KLA? Did you have an arm? Fuck your mother. Then all questions were only in Serbian language, which I did not understand. I had been interviewed for about 10 times, but in different offices of Djakovica SUP, HQ, but the interviewer was always the same and did not make any written notes. During the interviews, Apart from the interviewer, there were always present 2 other civilians who were beating me with baseball bats all over my body. On the 6th of September, that's the day after the statement you refer to, I recall that a man, I do not remember whether in uniform or civilian clothing, came to the basement and ordered us to sign some document. We were asking if he has translator to read us what we are going to sign. The man replied, "You will see translator." Then we were beaten again and forced to sign document without knowing the content. In October 2006, the ICTY read over to me a statement registered in the ICTY archives. As I already said, it could be the same as I signed in the premises of SUP in Djakovica, because I did never sign any other document. But I would like to raise my objections regarding the fact that I signed only 1 page. But the statement with the content I was acknowledged today as consisting of 4 pages. I would like to stress that there is no one word of true. I did not say anything what was mentioned in this statement as below. Now, if I've understood what you've told us already correctly, Mr. Steervich, you know nothing about the circumstances in which these men were detained, correct?
First of all, I don't know that they were detained. I don't have any information to that effect.
Well, there's, as I said to you, testimony from the senior officer at SUP Djakovica that they were detained, as well as there's the evidence in the statement you've read. But the question I'm asking you was, if they were detained when the statement was taken that you relied upon, you don't know whether they were tortured or not, do you?
Well, I don't know, but if you permit me, Your Honors, to say just a couple of sentences.
Well, are they an answer to the question? I mean, I thought you'd answered the question. You don't know one way or the other, is that right? I mean, a minute ago you told us you didn't know anything about the detention, Mr. Steervich. Did you or didn't you?
Your Honors, this is a complex question. I cannot reply with a yes or a no to this question. If you permit me to say a couple of sentences, perhaps it will be clearer. With all due respect, Mr. Emerson.
Before you do, Mr. Steervich, before you add whatever it is you want to add, it is a very simple question, and it is capable of an answer, yes or no. Do you know anything of the circumstances of the detention of these 11 men, including Nasser Kalamashi, between the 3rd and the 6th of September 1998? Do you know how they were treated during those 3 days? Yes or no?
No.
Thank you. So when you summarise the content of the statement and put forward its contents as reliable, you have no idea whether they're reliable or not, do you?
Ne.
Thank you.
No.
I guess that's the end of your cross-examination. Thank you so much.
Your Honours will be pleased to hear that's the last passage of video I need to play before I move to the concluding remarks. But that is the source of the material that Mr. Rogers chooses to put before you. At the beginning of the trial, it was shovelled in for what it was worth. At the end of the trial, it's cited in the closing speech and in the closing brief. Again, prosecuting serious cases carries responsibilities. Mr. Rogers then took me to task in his closing speech for referring to a document that was not admitted in evidence. And he told you that had been done by the Haradinaj defence at paragraph 185. Let me tell you what the document is and why it's not an objectionable point, because it's one of Mr. Stojevic's allegations that Mr. Rogers is yet again peddling. In support of the allegation that there were KLA blacklists of targets, we've already seen that he relied on a FARC list, not a KLA list, that wasn't a list of targets, but a list of missing and or wanted persons by witness 17. So that was the first list. The second list was put forward by the prosecution. It's a list that was said to have been found by the Serbian police when they overran Mr. Haradinaj's family compound on the 24th of March. He relies on that list. Where does he get evidence of that list from? He gets it from Mr. Stojevic's witness statement. Now, Mr. Stojevic, in his witness statement, refers to the fact that there was found in the premises a list of Albanians who were suspected of cooperating with the Serbian forces. That's to be found transcript 570, line 13. That testimony was based on his Rule 92 Ter statement relating to the search of the Haradinaj family compound on the 24th of March, which described that document as a list of individuals targeted for assassination as Serb spies. That is P121, paragraph 42. Now, the ruling of the previous trial chamber was that any aspect of Mr. Stojevic's 92 Ter statement that was not directly supported by documentary evidence would simply be ignored. And the trial chamber then went through the documents that he produced, throwing a very large number of them just exactly where they belonged, namely in the waste paper basket. One of them was that report, on the basis of which that passage appeared in the 92 Ter statement, and on the basis of which the evidence was elicited from the witness. That report was not admitted into the original trial, and the prosecution didn't seek to admit it in this trial. So to that extent, the allegation was unsubstantiated, remains unsubstantiated, and has no supporting evidence or probative value. But more importantly, the report itself, and the reason why it was chucked out rightly by the last trial chamber, says in terms that there's a list of names of Albanians, but the MUP, the police who found it, didn't know whether it was a list of KLA members or KLA targets. Now, if that isn't misleading prosecuting, I really don't know what is. That's the blacklist allegation. KLA communiques. The prosecution relies again in this trial on KLA communiques. We've dealt with this in our closing brief at paras 174 to 176. Can I put it very briefly? The man who wrote them gave evidence in the first trial. His name is Jakub Krasniqi. His evidence has been admitted. He says in terms that he didn't have any of the information or any conversation at any time with Ramush Haradinaj. They do not reflect any policy of Ramush Haradinaj. They were drafted by the General Staff, which, as you've heard, was this somewhat fanciful body floating around the Albanian border that never met and didn't even know who the members of the other members of the General Staff were. They were propaganda tools. They included lies. And above all, none of them refer to Mr. Haradinaj. None of them were seen by Mr. Haradinaj before they went out. None of them were signed by him or based on information from him. And they involve incidents outside the indictment area and outside the indictment period. None of them were authored by or emanated from Mr. Haradinaj, and they do not and cannot reflect any policy of his. They are worthless, and that, no doubt, is the reason why the former trial chamber regarded them in that way. So, Your Honours, that really brings me to three short points in conclusion. First of all, there are two remaining areas which, in our submission, are simply irrelevant to this case, that the prosecution have relied upon. There are two allegations that were not even, they were called but not even referred to in the judgment in the last case, because they were so irrelevant in relation to this allegation about Jablanica. The first is the suggestion that FARC was actively excluded by Mr. Haradinaj, and that there was this confrontation that took place shortly after their arrival. We've dealt with that in detail in our brief, taking it in a few short sentences. It had nothing whatsoever to do with Jablanica. It was a confrontation between two forces who were still then in conflict with one another, and where the soldiers at issue had driven without authorization into the area of responsibility of a force with whom they were in confrontation. And as the witness himself accepted, under the rules of engagement, they could have been shot dead on sight. But it was a conflict, regrettable as it may have been, that was resolved very shortly afterwards when the two forces came to agree on the distribution of officers and amalgamate over a period of time. And you'll remember the evidence in cross-examination concerning that. It's got nothing to do with an allegation to ill-treat detainees in Jablanica or to mistreat, torture or kill civilians. It was a conflict between soldiers and is miles away. It's not charged on the indictment. And though it was the subject of evidence in Trial 1, it doesn't even get a mention in the judgment, rightly so, because it's irrelevant, and we'd ask you to take the same approach. And finally, the Stojanovic allegation, again, very briefly, before the start of an armed conflict, spontaneous response by the villagers of Glodjane following that dreadful attack on the 24th of March, and their collective belief that the Stojanovics had not only provided information, but their correct understanding that the Stojanovic home had been used as, by the Serbian forces as in effect a military point from which to launch the attack. There's no evidence that Mr. Haradinaj was present. The evidence that was called at the original trial in that regard was regarded as unreliable, and there is no evidence that he participated in any way or condoned it. And whatever the position may have been, this was a spontaneous act of revenge by a community that had been ravaged days before by a dreadful attack that, let's not forget, was intended to be another precage, children shot point blank, and their response to a Serb family in their midst who had allowed their property to be used to launch that attack. So it really has nothing whatever to do with Jablanica. There's just two final comments, if I may. First of all, I said to you earlier on that your law clerks were going to need very, very carefully to look at every single footnote in the prosecution's closing brief, because regrettably I have to report to you that in the large majority of cases the footnotes do not support the citation, and in many cases they run flatly contradictory to what the prosecution claim the material represents. I'm not going to take time going through it because it will take too long, but we have prepared and will now hand up a schedule of the worst misrepresentations when you trace through the material in the footnotes. And finally this, if I may. I opened the submissions that I made to you by saying a little about Ramush Haradinaj as a soldier and as a politician. As a soldier, we say he fought an honourable war, and that is why he enjoyed the popularity that he did. As a politician, he forged consensus. He went into coalition government with the LDK, critically, and he was known for the protection that he sought to extend to all national minorities within Serbia, including the Serbs that had remained behind and other national minorities, a government of national unity. What's critical about that is that that has been his policy throughout, the protection of civilians. And the evidence in relation to that in our submission is overwhelmingly clear. The tragedy of this prosecution, which has now gone on for 7 years, isn't just a personal tragedy for Mr. Haradinaj and his family. It's also a tragedy for Kosovo, because they have been deprived of a leader who could have eradicated corruption and brought Kosovo fully into the international community. And they've been deprived of that through irresponsible prosecuting from the start, when Carla Del Ponte went shopping and fishing for prosecutors who take the brief after she acknowledges that she'd been advised there was no case, to the very end when Mr. Rogers shovels in evidence produced by Joran Stejovic, seeks to rely on it and then misrepresents it in his submissions, and then indeed has the gall to criticise me for putting that right. I just want to finish, if I may, by reminding Your Honours that at the back of the closing brief, and indeed in the back of this bundle, you have statements from the, first of all, the Special Representative of the Secretary-General of UNMIK, who was effectively running Kosovo during the period that Ramush Haradinaj was Prime Minister. That is Soren Jessen-Petersen, who's worked for the UN for 30 years, and was based first in Sarajevo, then in Macedonia, and then as SRSG in Kosovo from 2004 to 2006. And he describes Mr. Haradinaj in these terms. I was impressed by his performance as Prime Minister. He provided strong leadership, worked hard, and maintained constructive relations with all citizens of Kosovo, political parties, and the international community, including UNMIK. He was particularly effective in steering substantial progress on the implementation of the standards for a multi-ethnic, democratic, and law-abiding Kosovo, which the international community had established as criteria for leading Kosovo towards the beginning of the talks to determine the status of Kosovo. In that connection, the situation and the treatment of the minorities are very important. The Kosovo Serbs were of special significance, and as Prime Minister, Mr. Haradinaj took several initiatives to reach out to the Kosovo Serbs through personal action or by urging his cabinet members and citizens of Kosovo to do likewise. He then describes Mr. Haradinaj's resignation and voluntary surrender to The Hague, a decision which was taken by Mr. Haradinaj in recognition of the fact that if Kosovo wanted to be treated as a state and welcomed into the family of nations, then its Prime Minister needed to behave like a statesman and set an example and come here and face a fair trial. Unfortunately, he has not faced a fair prosecution. What does Soren Jessen-Petersen say about it? The same afternoon, that is when the indictment came through, Mr. Haradinaj had informed...
I'm sorry to interrupt, but I don't think either of these statements are admitted into evidence.
They are. They're both appended to our closing brief.
I know they're appended to the closing brief.
Together with a statement indicating they'd be referred to in closing submissions, no objection has been taken in relation to that.
But that's a different point.
Well, you've had your opportunity to object.
Just a moment, please. The question is whether or not they're admitted into evidence, and they're not.
Unfair to the last, Mr. Rogers. I'll ask Your Honours for a ruling.
The Chamber accepts the statements.
Thank you.
Thank you.
The same afternoon as the indictment was received, Mr. Haradinaj had informed all concerned, had announced his resignation, and had also been helpful in arranging for the surrender of his two co-indictees. In his public announcement, he appealed for calm in Kosovo. And in my statement, I did the same, while at the same time regretting the departure of the able Prime Minister, while commending him for his example in cooperation with the Tribunal. I also expressed my regret that I would no longer be working with a friend, a statement that raised many eyebrows. But for me, it is clear that a friend is somebody I can trust. Klaus Reinhardt.
I was just going to assure you that the Chamber has read even the next one.
I'm grateful. Would you want to just permit me to place one passage on the record in those circumstances, a very short one? Klaus Reinhardt, a 41-year star general in the German armed forces, was commander of KFOR, the international peacekeeping force in Kosovo, whilst Mr. Haradinaj was Prime Minister. And he says this: Mr. Haradinaj is a highly intelligent and honest man whom I trusted wholeheartedly and whose advice I sought actively. He never let me down, nor did he ever misuse my confidence in him. I enjoyed his open and convincing character, his charismatic leadership, his absolute reliability, and his deep humour. Mr. Haradinaj is a born leader, dedicated to changing the poor living conditions in Kosovo and to stopping the ethnic fighting among the peoples of Kosovo. He was and is a man with a vision for a better future for the different ethnic groups in Kosovo, in particular for all the minorities. He was the only Albanian Kosovar leader I met who always asserted how important it was to reconcile with the Serbs and other minorities and to give all refugees a fair chance to resettle in Kosovo. He didn't say that to please me, but he was, I believe, deeply convinced that otherwise the internal struggle in Kosovo would never stop and the people of Kosovo would never get a chance for a better and peaceful future. That is what the prosecution in this case, based as it has been from start to finish on evidence which wouldn't hang a cat, has deprived Kosovo of. We invite you to show Mr. Rogers and the Office of the Prosecutor the door.
Thank you, Mr. Emerson. Mr. Guy-Smith?
My turn?
Sir.
If I could impose upon Mr. Emerson for the podium.
Mr. Emerson.
This, as you well know, is a retrial. And we're not on virgin territory. Convictions and acquittals have taken place concerning these men, predicated on the testimony of the witnesses who have been discussed with you thus far and who we trust, will review in depth and extensively. We believe that there's little, if any, doubt that a vigorous examination of the first trial, and perhaps the necessity of sitting and watching the actual testimony may well be required. It's important to remember something here, and it seems to have been forgotten, which is in the first trial, in which there was a full acquittal for Mr. Balaj, the gentleman with the hideous reputation. No affirmative evidence was presented on his behalf because the prosecution failed to prove the case against him. And in this trial, once again, from the outset, let us be very clear that the prosecution has failed to prove the case against him beyond a reasonable doubt. He is entitled, again, to an acquittal. Cast as many aspersions as you wish, Mr. Prosecutor. Discuss his foul or vile reputation as much as you want. It does not change the fact that the evidence that has been presented is wanting in the first instance, in the second instance, and in the final instance. Now, I've given a fair amount of thought to a particular part of my discussion. And at one point thought it perhaps would be something to avoid. But having listened to the remarks of yesterday, and having once again revisited the testimony of particular witnesses today, I feel it incumbent to remind all of us that this is not a boxing match. This is a court of law. And in a court of law, there are certain duties and obligations that devolve to the parties and specifically to the prosecution. Because the prosecution is the representative of not an ordinary party to a controversy. Therefore, in a criminal prosecution, its interest is not that it shall win a case, but that justice shall be done. As such, the prosecutor is in a peculiar and very definite sense the servant of the law, the twofold aim of which is that guilt shall not escape or innocence suffer. He may prosecute with earnestness and vigor. Indeed, he should do so. But while he may strike hard blows, he is not at liberty to strike foul ones. It is as much his duty to refrain from improper methods calculated to produce a wrongful conviction. Let me repeat that. It is as much his duty to refrain from improper methods calculated to produce a wrongful conviction as it is to use legitimate means to bring about a just one. That's a quote from a case in the United States, a Supreme Court case called Berger versus United States. It's a quote which certainly recognizes and articulates the duty of a prosecutor, particularly in a criminal trial. But lest there be any doubt that that standard is perhaps too high, promulgated here in the International Criminal Tribunal for the former Yugoslavia, Prosecutors Regulation Number 2, since 1999, Standards of Professional Conduct for Prosecution Counsel, Section 2, sub E, in the conduct of investigations, in the conduct of pretrial, trial, and appellate proceedings, prosecution counsel will adopt the highest standards of professional conduct. The prosecutor expects them consistent always with the letter and spirit of the relevant statute and rules of procedure and evidence. E, to demonstrate respect and candor before the tribunal, and not to knowingly make an incorrect statement of material fact to the tribunal or offer evidence which prosecution counsel knows to be incorrect or false. Should prosecution counsel become aware that a statement made to the tribunal is incorrect, or that evidence presented to the tribunal is false, he or she shall take all the necessary steps to inform the tribunal as soon as possible. It has been recognized that intentionally misstating the evidence or misleading the fact finder regarding permissible inferences to be drawn, which in this case is central to the prosecution's theory that you draw a series of inferences, that such behavior is misconduct. How you choose to deal with that directly reflects on how you choose to view the evidence that has been presented to you. And thus far, it is clear that you have received evidence from the prosecutor which came about through bribery, through blackmail, through torture, and there have been misstatements. And let's start with the issue of misstatements. And specifically, as it relates to Idriz Balaj. Paragraph 18 of their brief. Quote, "It was like a secret, comma, a public secret, comma, everything which happened in Dukagjin, if it was not proved, then everybody said this was done by Togeri, brackets. That is what we heard And that was how it happened. Everything bad that happened, it was attributed to the Toger. Well, if that was in fact what the gentleman had said, pretty problematic statement and a troublesome one. But that's not the full quote. The brackets were left out. The information that was contained in those brackets were left out. And I will read it again. It was like a secret, a public secret. Everything which happened in Dukagjin, if it was not proved, then everybody said that this was done by Togeri. However, comma, this is only hearsay, and there is nothing confirmed. Period. This is what we heard, and that was how it happened. Everything bad that happened, it was attributed to the Toger. That's a very different statement. And there's something else which was said in that same context. I'd like to say something else. That Toger was not somebody known to the population. He came to assist in the war. So people mention his name. In the remarks yesterday, and also cited in the brief, I believe it's in their brief at paragraph 46. Footnote 156. This is concerning testimony from John Crossland. It's used as a quote to establish that the KLA were involved in the murder of 6 Albanians deemed Serb sympathizers. And Mr. Crossland did in fact say that. But he went on to say the following, and this is another example of which there are many. The brief is legion with these examples. The following. It asked a question. This is P9 at page 1882 concerning the same issue. Did you see the bodies yourself? We did see the bodies, but there was really no conclusive evidence as to how they came there and who had shot them and who had shot whom. This is all part of, I said, the fluid situation that prevailed throughout 1998 and 1999. Now, if the testimony that was received in this trial was that the witness didn't know how the bodies got there, didn't know who had shot them, do you think it's misleading for it to be suggested to you that that testimony, that that gentleman's testimony stood for the proposition that KLA killed people because they were Serb sympathizers? Because that's what you're being asked to infer. And that's an important inference here for the prosecution. But it's worse than that, actually, for a moment, in dealing with the issue of Serb sympathizers, specifically in dealing with the issue of Idriz Balaj, who is claimed to have targeted collaborators and sympathizers. P53, Suf Krasniqi, discussing specifically the issue of a collaborator. Question. He received permission from Ramush Haradinaj and Togeri. Is that accurate? Starting at page 5840. Answer. Well, we're talking about Salih Shrekrili now, who was a collaborator of the Serbs, together with his family, and he was interrogated. After the police withdrew from Kalapek station, Salih expressed his wish to become a member of the KLA to protect his own village. He came and said that Ramush, Toger, and whoever else was with him, they had said that he was free to move in the area. I did not see that paper. He told me that he'd been left free to move around in the area. Soldiers also told me he'd been given permission to move freely. However, who gave him that permission, I don't know. Question. But the information that you've given us was that he was given permission to move around the area by Ramush Haradinaj and Togeri. Correct? Yes. Correct. And then he goes on. This is not the picture that has been painted of Idriz Balaj. This is not the evidence that has been argued by the prosecution concerning Toger. A man who, in the face of knowledge of a collaborator, which as far as Mr. Rogers has posited, means a death sentence, gave him permission to move in an area and to be free. What's the inference to be drawn? Now, if there's an inference to be drawn, and we're dealing with the issue of circumstantial evidence, I think we all know the answer. The conclusion to be drawn from circumstantial evidence has to be, if it's for guilt, the only conclusion that's available. Here you have affirmative, indisputed evidence that suggests an analysis entirely distinct from that which has been offered. I always thought it better to allow myself to doubt before I decided than to expose myself to the misery after I had decided of doubting whether I had decided rightly and justly. It's a quote from Lord Eldon discussing the issue of reasonable doubt. And in defining reasonable doubt, which...
May I interrupt you?
Yes.
You're obviously going into a slightly new topic.
I am stopping right now, Your Honor.
Thank you so much for your kindness. We'll take a break and come back at 12:30, 12:15.
All rise.